Namaskar. Welcome to a new episode of BHARATIYA NYAYA SANHITA 2023. Today we continue with the discussions of the definitions of certain legal provisions in the BHARATIYA NYAYA SANHITA 2023. Section 236. Wrongful gain means gain by unlawful means of property to which the person gaining is not legally entitled. The corresponding provision is provided under section 23 of the Indian Penal Code. Wrongful gain. Wrongful gain is gain by unlawful means of property to which a person gaining is not legally entitled. Wrongful gain means by unlawful means of property, gaining something for which a person is not legally entitled. In other words, a person having some unlawful gain, actually he is not legally entitled, but by some unlawful means he is getting something. What is that? For example, extortion, theft, cheating, blackmailing, or some other deceptive means. If a person has got a mobile phone, that person is entitled for that. He purchased it, he has got the bill, he has got the valid title. But the very same mobile phone, if someone steals or making theft of that mobile phone, he is getting it as unlawful gain. He is not legally entitled. It's a wrongful gain. And if such type of gain is said to be wrongful gain under law. This can be yet another result of extortion. The difference between the theft and extortion is when theft is committed, the owner of the property is not aware of that. When we travel in a bus or train, someone steals something from our pocket, we may not be aware of that. Whereas in extortion, the person committing the offense of extortion, putting the other one under fear, and under that fear, he is getting something. Means with the knowledge of the owner, the person committing extortion is getting the mobile phone. So unless you give me that mobile phone, I will kill you. Then, if a knife is shown, then under the fear that owner is giving the mobile phone to the other one, then it is extortion. So, in both ways, person gaining that property is getting wrongful gain. Why? Because he is not legally entitled for that. Sometimes in cheating matters, when some deceptive methods are applied, for example, currency notes. If you give me one currency note, I will make a counterfeit currency note and give you 200 rupees. So getting one, giving two. Actually, it's only a cheating. The person getting that one currency note which is legally valid is not legally entitled because it belongs to someone else. Putting someone under pressure, അല്ലെങ്കിൽ fear or some deceptive methods, I am getting it. Then also the person getting that property or currency note, he is getting wrongful gain. This is what is meant by wrongful gain in the eye of law, which means a person gaining that property is not legally entitled, but by some other method, deceptive methods, or some other illegal means he is getting it. He is not legally entitled for that property. Wrongful laws, section 2, subsection 37, means the loss by unlawful means of property to which the person losing it is legally entitled. The corresponding provision in the Indian Penal Code is again in section 23, second lib, wrongful laws. Wrongful loss is the loss by unlawful means of property to which the person losing it is legally entitled. Wrongful loss is just opposite to wrongful gain. If a person getting some property which he is not legally entitled by wrongful means or by wrongful gain, then the person losing, he is actually entitled for that. The mobile phone which is stolen from someone, he is the actual owner, and his loss under law is defined as wrongful loss. So in other words, it is in the eye of law, the person who is actually entitled, legally entitled, is losing it. So losing the ownership of property by unlawful means is defined as wrongful loss in BHARATIYA NYAYA SANHITA 2023. So the wrongful actually we can means illegal. So illegal loss, illegal gain. That's a simple meaning of wrongful loss and wrongful gain. Section 2, subsection 38 says, gaining wrongfully and losing wrongfully. A person is said to gain wrongfully when such a person retains wrongfully, as well as when such a person acquires wrongfully. A person is said to lose wrongfully when such a person is wrongfully kept out of any property, as well as when such a person is wrongfully deprived of property. The corresponding provision is under section 23 of the Indian Penal Code again, which says, gaining wrongfully, losing wrongfully. A person is said to gain wrongfully when such a person retains wrongfully, as well as such a person acquires wrongfully. A person is said to lose wrongfully when such a person is wrongfully kept out of property, any property, as well as when such a person is wrongfully deprived of property. Until now, we were discussing about the wrongful gain and wrongful loss. Now, that is only a noun. This is a verb, means doing something. Gaining wrongfully, losing wrongfully. A person is said to gain wrongfully when he is acquiring a property by wrongful means or illegal means, or if he is legally entitled but retains illegally, then also it is said to be gaining wrongfully. For example, if a person see the mobile phone of another one, until now no offense is committed, but if he is taking steps to steal that mobile phone, that process is known as gaining wrongfully. He goes there, he whacks that other person and deprives his attention, and he takes that phone and going out. This entire process is known as gaining wrongfully. And there is yet another situation. For example, a person is going to bathroom, before which he gives his mobile phone to you. Please keep it until I go back from the washroom. Now, if a person is in possession of that mobile phone, though it does not belong to him, it is not illegal. But by the time that other person has gone to the washroom, this person just leave the area, then he retains that mobile phone by wrongful means. That is also said to be gaining wrongfully. So the property may come to your hand by lawful means, but if you retain it illegally, then it is known as losing, gaining wrongfully. Just opposite to that is wrongful loss or losing wrongfully. The other person who was in the possession of the property, by the very same process, lost it. So he is kept out of the property and he is deprived of the property. That process is also known as losing wrongfully. Kept out of the property, he is entitled for that property, but by some other wrongful means, that person is not allowed to keep that property. And he is actually deprived of the property because before coming to the washroom, the other person has just left. When he comes out, he is actually deprived out of that property. So that is known as wrongful, losing wrongfully. Simple difference is wrongful gain and wrongful loss. And gaining wrongfully and losing wrongfully is one is noun, other one is verb. The process is known as the second one, other one is the offense. This is the simple difference. Coming to the next point. Section 2, subsection 39 of the Bharatiya Nyaya Sanhita says, words and expressions used but not defined in this Sanhita, but defined in the Information Technology Act 2000 and the Bharatiya Nagarik Suraksha Sanhita 2023 shall have the meaning respectively assigned to them in that Act and Sanhita. As I told you earlier, in a statute, in a law, there is a meaning for every word, and we can find in the definitions. Now, this particular section says, if any word is not defined in section 2, but used in the statute, that is to say, Bharatiya Nyaya Sanhita, then the meaning given to that particular word under the Information Technology Act 2000 or Bharatiya Nagarik Suraksha Sanhita, then if such a definition is given in that law, this is section or this particular word will have the same meaning even in the other statutes. So this is yet another peculiarity of law. If a particular word is not defined in a particular statute, but defined in some other statute, then we can understand the meaning of that particular word from the other statute. That is known as extra help from the statute. Normally, the meaning of a statute or words in a statute within the four corners of that statute. But we can have some external help, some other pari materia, if available in some other law, and meaning is particularly assigned in that particular statute or code or sanhita, then that meaning can be taken into account while interpreting a particular statute. And if it were not defined, then there is a General Clause Act. And if a meaning is given under the General Clause Act, then that meaning can be assigned to a particular statute. And if that is also not defined under the General Clause Act, then the court is entitled to have the meaning given under the dictionary or in the ordinary parlance. That also can be interpreted. There are instances in which court has got external aid other than in a statute from the pari materia or General Clauses Act or from dictionary or from the meaning given in the common parlance. These are the methods that are adopted by court by finding out the meaning of a particular word in the statute. The discussion will continue in the next episode. Thank you.